The following are the issues which effectively determine the decision. One, whether having regard Because he was fined his farm with $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in exhibition has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I am finding that by the provision of sections 52 and 65 of the Electoral Act 2022, the correct interpretation of said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so whole. Consequently, this matter is hereby dismissed. Clause of court. It is tried law that for a judgment of a court to constitute estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. The Anchorage Leisures Limited and others versus Eco Bank Nigeria Limited, and Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that INEC was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent result viewing portal, IRF, in real time. First, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred averments in this petition and the relief sought by the petitioner in in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system. With the judgment of the settled law that unappealed decision of the court remains subsisting, binding on the parties. The Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the Lagos Division of this court in appeal number CA/LAG/CV/332 2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FHC/L/CS/370/23, Labour Party and others versus ANIC. Another case forum shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CA/LG/CV/332/2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner contention which they are making in this petition, that INEC is mandatorily required to electronically transmit election results. By virtue of Section 122, subsection 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CA/LG/CV/332/2023, APC versus Labour Party and 42 others. Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and ordinary regulation guidelines for the conduct of elections, the first respondent cannot be compelled to electronically transmit election results. the petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seems to us that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of the petition, while specific allegations of corrupt practice were made in paragraph 60 to 78, even though some were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced below. I've produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted. Particularly, the first respondent directly denied the allegation of non-stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines respective for the conduct of election. In particular, stated that the first respondent denied that there was any collation system was manual collation on the various from which polling unit results were mandatorily required to be electronically transmitted, and the first respondent directly denied the allegation. Paragraph 31 of the first respondent's reply. He also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. They also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the IREF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the IREF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25th February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IREF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the IREF portal because it could not map the results uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error from technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the IREF portal. The results are available as generated in their original form from the polling unit using the beavers. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was any technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to upload the presidential election results using the beavers to the average was a ploy to manipulate the actual results of the election. As indicated in their pleadings and submissions of counsel, the petitioner's allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 22 is anchored on the provisions of sections 47.2, 61, 2 and 5, 64.4a and b, 64.5 and 73.2 of the Electoral Act, and paragraph 38.1 and 2, 48a, b, c, 55, Roman 5, 7 and 20, 51.2, 54.12 and 55.12, 93 of the regulations and guidelines. I have carefully considered the submissions of the parties on this issue of non-compliance with the Provisional Electoral Act and the paragraphs of the regulations and guidelines for the conduct of the election 2022. The Independent National Electoral Commission, the first respondent herein, is established by Section 153, subsection 1F of the Constitution of the Federal Republic of Nigeria 1999, and part of its functions are stated on paragraph 15 in Item F, Part 1 of the third schedule to the State Constitution, is to organize, undertake, and supervise elections, including election to the office of the President and Vice President, among other political officers listed. In a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158, subsection 1 of the Constitution, INEC shall not be subject to direction or control of any authority person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64.4 states that a collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected result are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and B, the votes stated on the collected result are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 64.4a, relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 44b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64(5) that the collection officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collection or return officer will use to verify and collect the results, subsection 5 also provides for what the collection or return officer will use to collect the results. Subsection 6 of the same section provides for what the collection or return officer will use to determine the correctness of disputed result where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, subsection 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64, sub 4 of the Act, which requires only the counting and announcement of the results polling unit. A careful examination of the above sections, slide opened by the petitioners, show that the Electoral Act had used the words deliver in Section 62, subsection 1, transfer in Section 60, subsection 5, and transmitted directly in Section 50, sub 2, 64, 4, 5, and 6 of the Electoral Act 2022, in stating how results of election should be handled under those provisions. A look at the definitions of those words in the Black's Law Dictionary 6th edition shows that the word transfer is defined at page 1497 as to convey or remove from one place, person, etc. to another, or to pass or hand over from one to another, or to specifically to change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1991 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent does annex herein made the regulations and guidelines for the conduct of elections 2022, as well as annex manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation of non-compliance on paragraph 38(1) and 2, 48A, D, C, 55 and 7 and 20, 51(2), 54(7), 55(7), and 93 of regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive, you get a copy of the guidelines you will see. Here we have to produce it in this judgment. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents were available, such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system, in addition to the physical transfer of the election results to the registration area of ward collation officer. As stated earlier, the technological device as prescribed by ANIC in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38, 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANEC result viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANEC results viewing portal, IREF, is not a collation system. The Supreme Court in Oyetola and ANEC 2023, ANEC 23 LPELR, has explained the difference between the collation system and the IREF. In that case, AGIM JSC held as follows: court. As their names depict, the collation system and the ANEC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANEC Manual for Election Officials 2023 show that the Electoral Act provides in Section 62, subsection 1, that after recording an announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANEC manual, also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IREF will be used to collect results. The petitioners who contend that ANEC was mandatorily required to electronically transmit the election results to the collation system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that ANEC was mandated to electronically transmit or transfer the result from the polling unit direct to the collation system as prescribed by ANEC. He stated that the IREF portal is part of the technological architecture developed or deployed by ANEC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the BVAS machine, and that his investigations and findings were on the ANEC IREF portal. He also agreed that it was only ANEC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine INEC compliance with the Electoral Act 2022 and the INEC regulations and guidelines for conduct of the elections 2022. He prevaricated under cross-examination by the first respondent when he first stated that INEC at the RF portal is an electronic collation system, but later recanted and said the RF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to RF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, our evidence was basically in respect of the health status of Amazon Web Service, which hosted the INEC RF portal. The testimony of PW8, the cyber security expert, also called by the petitioners, also related to the INEC RF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the Beavers machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that INEC has not established any collation system to which results will be electronically transmitted from the polling units. Thus, his testimony on that fact remained unchallenged and uncontroverted. It is settled law that the court has a duty to act on unchallenged and uncontroverted evidence. The Bromwen Energy Trading Company Limited, OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third respondents, had testified that the first respondent, through its chairman, made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by the first respondent, as such transmission was susceptible to hacking. He identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of Tribune newspapers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. Although also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the ANEC chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the ANEC RF portal, none of the witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners, that under the regulations, it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results. Paragraph 92 of the same regulations categorically provides that at every level of collation, where the annex copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulations provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of clause 93 of this regulation shall apply. The said clause 93 of the regulations, which I had earlier quoted, provides that where the annex hard copy of collected results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the RF portal to continue collation. And where none of this exists, the collation officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the annex regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collation of results. There is nothing in the Electoral Act or the annex regulations and guidelines to show that an electronic collation system was prescribed by the Commission, to which results will be electronically transmitted. Thus, the petitioners were unable to establish the assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. The first respondent, on the other hand, has adduced unchallenged evidence that apart from the annex RF portal, no collation system was established by the first respondent to which the result of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results, and the electronic transmission to a collation system apparently introduced by the first respondent in the regulations and guidelines are not mandatory as contended by the petitioners herein. Also, my finding based on the evidence adduced that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the physical collation centers in the registration areas or ward collation centers, local government area collation centers, state collation centers, and the national collation centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the annex result viewing portal, RF real time, the petitioners averred in paragraphs 53, 97, and 98 the petition that the petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent, via a written communication, sought to excuse the manifest non-compliance with the requirements of the Electoral Act 22 and the regulations by claiming that there were glitches in the electoral system which prevented it, that first respondent, from uploading the results of the presidential election from the polling units to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. The petitioner shall contend that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to credit unlawful votes to the second respondent and thereby wipe out the clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent adverted in paragraphs 59, 55, 7, 8, 9, and 10 of their reply to the petition that I've reproduced them here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server contents of the IRF hosted on the AWS cloud platform to show that the results of the election were uploaded on the IRF portal, but the first respondent attempted to delete or remove the uploaded results. It is true that a petitioner who alleges non-compliance with the Electoral Act has the legal burden to establish that non-compliance and show how the non-compliance substantially affected the result of the election. Ladoja and Ajimwabi, Shinkafi, and Yari, in proof of their assertion, the petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not front-loaded along with the petition, as mandatorily required by paragraph 45 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I had upheld the respondents' objection and struck out the evidence, which include their witness statements on oath and the documents and or reports tendered through them. These are exhibits PCJ-A to F, PCJ-4, 6 reports of AWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7 and PW8 and the other witnesses called by the petitioners. PW7 claimed to be a cloud engineer or architect, an employee of Amazon Web Services. She stated that she is not only a member of the Labour Party, the petitioner is in, but she contested election as a candidate for member House of Representatives for Ogoja, Yala, Federal Constituency of Cross River State. He stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Collation centers and design, yes. The development from implementation, testing the code, staging the software and development and deployment. She stated that she was aware that at the process of testing and staging of software code and problems or challenges, any problems or challenges with the software will usually show and or be flagged. She stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying the software. He stated that if a software from application has any glitch, such a glitch will pop up, that is flagged at the testing stage. He stated that from her preliminary review of the public viewing facing the RF website, she is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. He stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA Amazon S3 latest user guide from data durability.html. He stated that the AWS code servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.aws.amazon.com health status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. It stated that from the post-event summary PAs by AWS. The last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues affecting only one region. He said this is available to the public. EW7 stated that she was aware that a glitch in the software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software to change its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed production maintenance, which is an important element of software development life cycle. He denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. He stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. He admitted that the EWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. He admitted that the report that only shows the health status of all AWS services in all regions in terms of the infrastructure and not security. He admitted that in order to know what happened on applications deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. EW7 also stated that she is familiar with AWS CloudTrail, and there is a CloudTrail for every AWS account and for every API action made on that account. She admitted that she did not produce the CloudTrail for any deployed application before the court. He denied that the CloudTrail is the best account of what transpired on any deployed application, but did not state the best way to know what transpired. He stated that it is highly unusual for glitches to occur for primary functions of applications in production. He stated that she was not aware that glitches happened with the Central Bank of Nigeria e-money project, or the one that happened with the MTN Mono PSG. He admitted that she was a candidate for the Labour Party at the last election. She also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on cross-examination by the second and third respondents, EW7 admitted that Exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. She also admitted that she had been attending the court and watching the proceedings before the day of her testimony. She admitted that the report she presented before the court is public information posted by Amazon and that it is available and accessible to the public. She, however, insisted that the report is hers because she was the one who downloaded it, brought them to the court. PW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against ANEC because she was not placed on the final list of candidates published by ANEC. She admitted that her complaint was because she tried several times to upload her information on ANEC's site, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application, even as she disagreed that there was a glitch on ANEC's site. She admitted that in her affidavit. She stated that ANEC's site crashed. EW7 also stated that she was aware that EWS experienced outage of several hours on Tuesday, 28 February 2017, and that as at 2021, AWS also was reported to have suffered more than 27 outages. He also admitted that what was sent to RF was the image of the Form EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocol to modify the applications of ANIC. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. However, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was in December 2021. As to whether glitches can happen again, she stated that anything is possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the ANIC regulations and guidelines for the conduct of elections 22 and the ANIC manual for election officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the beavers to IRF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed for production. On cross-examination by the first respondent, PW8 stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On 17th and 18th March 2023 and concluded the final report at the end of May 2023. PW8 stated in paragraph 14 of this his adopted written witness statement that he read the petition and the first respondent replied to the petition in doing his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units to establish that it is possible to show metadata. He stated that there were errors in those polling units and he did not have to examine the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the CloudTrail and confirmed that the CloudTrail will explain the availability of the application of ANIC on the AWS infrastructure. PW8, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of Exhibit ECK2 and stated that it means an electronic collation system. When cross-examined by second and third respondents, PW8 denied that it was part of his brief to assist the Labour Party to respond to the respondent's reply. He admitted that he did not inspect any of the beavers' machines and did not interrogate Festus Okoye, whose statements he referred to. He confirmed that Exhibit A, which he attached to his report, is the metadata of 23 pages showing multiple uploads. He denied that it contains information which are coded and not explained, and insisted that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report, but stated he did not expect the court to go and browse access and download the information contained from those links. When cross-examined by the first respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IREF, and he did not interact with the presiding officers of those polling units and did not see the hard copies of those results. He could not also tell whether those results have been collected. Starting with the evidence of PW7, it's evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she had been attending court and watching the proceedings prior to making her statement on oath and testifying as a witness. Her testimony, therefore, was essentially a demonstration of her support and loyalty to the second petitioner. Her claim to being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a worthless paper. It has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not in terms of security. She had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded. And her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responders application posted on the AWS is not before the court. Her conclusion on the totality of this witness is that it is devoid of any probative value. As for PW8, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collation centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collation centers. The petitioners have left no evidence to establish the existence of any collection center to which the potential election results were to be electronically transmitted for collation. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the IRF portal real-time on 25th February 2023 was due to a technical glitch experienced on their e-transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent that polling unit results being uploaded to the annex e-transmit system by the presiding officers were pushed to the Senate and House of Representatives modules on the IRF, but the results of the presidential election were not being pushed to the presidential module on the IRF. That based on threat levels and reports by security agencies that the first responder servers may be subjected to attacks on election day, the first responder first course of action was First course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack, but the issue was a HTTP 500 error from which the application, within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly. That a thorough investigation revealed that the e-transmission was unable to map the uploaded results of the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure to organize the uploaded results in the hierarchy of election, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system. And that the whole system randomly saved uploaded results by timestamps, making it difficult to upload results sheets by election or by state. He stated that the deficiency was observed after the Ocean State governorship election in 2022. RW1 stated that during the election of 25 February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies to their respective states. And that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy for the results organization. But for the presidential election, the application crashed because the presidential election does not belong to any state on the first respondents database, and any attempt by the application to build a folder structure to organize the election results failed with a HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. He stated that the first presidential election results were successfully uploaded at 8:55 p.m. on the 25th February 2023. He further stated that to confirm that the glitch actually happened, as well as the time that all patches to fix the error were created and deployed, can be viewed on AWS Cloud Trail and AWS functionality that allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the Cloud Trail logs. He stated that the technological glitch experienced on the e-transmission system was not a ploy to manipulate the election, and the glitch did not affect the results of the election. He then tendered exhibits RA6 and RA7, the Cloud Trail log, and his certificate of compliance with Section 84 of the Evidence Act 2011, and identified same as the documents he referred to in his witness statement on oath. Under cross-examination by the petitioners, RW1 confirmed that testing was carried out on the e-transmission system, the first respondent, on the 4th February 2023, before it was deployed and a report was issued. When shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. The petitioners then tendered the report of vulnerability assessment and penetration testing through its witness, which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, the burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2011. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. The first respondent, on the other hand, has offered credible evidence in the form of exhibits RA6 and RA7 to show that its e-transmission application posted on the Amazon Web Services, which is supposed to upload the results of the presidential election to the IREF, has suffered a glitch on the election day on 25th February 2023. On the preponderance of evidence, I am convinced that the petitioners have failed to establish their assertion that the first respondent had deliberately failed to upload the results of the presidential election to the IREF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC Manual for Election Officials 2023. By Section 134, subsection 2 of the Electoral Act 2022, only an act or omission which is contrary to the Electoral Act 2022 can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints for questioning an election. In interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134(2) of the Electoral Act 2022, the Supreme Court held in Nyesom and Peterside as follows. Quote, the above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections by Section 138(2) of the Act, so long as an act or omission regarding such regulation or guideline is not contrary to the provisions of the Act itself, it will not of itself be a ground for questioning the election. See also Jegede and INEC. Since, as shown above, the electronic transmission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the regulations and guidelines for conduct of elections 2022 and INEC Manual for Election Officials 2023, the failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1B of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received, reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC 8B1, in respect of the states where the second respondent duly won the election, as shown in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that it duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1 as alleged by the petitioners. Complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access with regard to the state of the pleadings and the issues of fact in contention, the onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73, subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. Relied on the decision of this court in First Bank Nigeria PLC, Adjoition Business Investments, and Royal United Nigeria Sterling Bank PLC, submitted that the first respondent did not leave any evidence in proof of their positive assertion there was compliance with the said provision of Section 73, subsection 2 of the Electoral Act. Learned Counsel submitted that on the part of the petitioners, they have led evidence through PW 12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as exhibits PCQ 1 to PCQ 6. He added that the petitioners have also served subpoena duties take home on the first respondent to produce the said forms, but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the forms. Counsel urged the court to invoke the provision of Section 167D of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with Section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Gawa, Kogi, Kwara, Niger, Ogun, Ondo, Oyo, Rivers of Zamfara states, which are shown in the form ECADA, admitted in evidence as exhibit PBF. He pointed out that Section 135, Section 1 of the Title Act 2022 only deals with non-compliance generally, but Section 73, Subsection 2 of the Act has provided a specific effect of non-compliance with provisions. Relying on Crown's Townsend Organization for the National Institute of Policy and Strategic Studies, he urged the court to hold that substantial non-compliance has been established by the petitioners. Arguing per contra, Learned Senior Counsel for the first respondent referred the court to Section 135(1) of the Electoral Act 2022 and submitted that the petitioner complained of non-utilization of prescribed forms, even though not proved, cannot without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude Section 73, subsection 2 of the Act from the ambit of Section 135, Section 1 is a non-starter because the non-compliance referred to in Section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with Section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved such non-compliance nor shown that it has substantially affected the result of the presidential election. I urge the court to so hold. Petitioners had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the petitioners have neither asserted the burden of non-compliance nor established that they have duly complied with the provisions of Section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Adjoition Business Investment Limited, Royal United Nigeria for Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Anik, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation rests on him, close of court. Again, This court in Dashi and others versus Druven and others espoused this legal position when Ugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who substantially affirms the positive of an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ and Abrath was a Northeast Railway Company, 11 Queens Bend Division 440 at 457, when he said that, quote, in an action for malicious prosecution, a plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are, after all, relative and not absolute. Close of quote. In the instant case, the petitioners have made their allegation of non affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election. It encompasses non-compliance with all provisions of the Electoral Act, including Section 73, subsection 2 thereof. In other words, Section 73, sub 2 is not derogated from the ambit of Section 135, Section 1 of the Act. Indeed, in Buhari and Anip, Toby Joy is while considering considering Section 145(1) of the Old Electoral Act, similar to Section 135(1) of the Eastern Electoral Act 2022, had held at page 48, paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1) of the Act, the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73, subsection 1, as part of their course of action, have the burden to establish that non-compliance in accordance with the requirements of Section 135(1) of the Act. The petitioners have also relied on the evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits are acknowledged copies of letters dated 6 March 2023, 14 March 2023, 16 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman of the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioner also relied on subpoena duces tecum served on the first respondent to produce the said form. In his testimony at paragraphs 58 to 60 of his adopted written statement on oath, PW12 merely stated that the petitioners made several applications through its campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30th May 2023 and 13th June 2023 were issued on the chairman of the first respondent to produce some documents. The record also shows that on the 20th June 2023, one Olufunmilayo Taiwo, the Deputy Director of Certification on Complaints and Legal Drafting with ANIC, appeared on behalf of the first respondent in answer to the subpoena Duchess Tekum. While she produced some of the documents required of the first respondent in the subpoenas, she informed the court that the documents listed in the subpoenas as listed E, C, D, and E are in the states. And since the subpoena was served on them just before the previous day, it will take some time for the first respondent to get them. An examination of exhibits PCQ to PCQ6, which were tendered by the petitioners through PW12, showed that all except exhibit PCQ are letters addressed to the chairman or the first respondent by the petitioners and their solicitors requesting for inspection of documents and for certified copies of those documents. Exhibit PCQ4 is a covering letter addressed to the resident electoral commissioner, Benue State, from the law firm of Dr. Onyechi Piazzo, SAN and Co., notifying the respondent, the resident electoral commissioner, of subsequent action on the solicitation letter by the national chairman, ANIC headquarters, Abuja, dated 6 March 2023. It is instructive to observe that Section 74(1) of the Electoral Act 2023 mandates the resident electoral commissioner in a state where an election is conducted within 14 days after an application is made to him by any of the parties to an election petition, cause a certified true copy of such document to be issued to the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits an offense and is liable on conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 showed that they were all addressed to the chairman of ANIC instead of the resident electoral commissioners in the states, as required by the petitioners, by Section 74, subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures of requesting for those documents. More so, when the record shows that the subpoenas, which they claim to have served upon the first respondent, were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 had stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, he stated that he was neither a polling agent nor a collation agent. His evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with Section 73(2) of the Electoral Act. The Electoral Act 2022. Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to comply with the provisions of Section 73, Subsection 2 of the Electoral Act 2022. Rather, PW10, Jeffers Ia, the supervisory presiding officer for Madagali Ward in Adamawa State, who was subpoenaed by the petitioners to testify on their behalf, had stated in paragraphs 4 and 5 of his witness statement of oath that as a presiding officer, he reported to the local government area INU offices in Gulam, Madagali local government area in Adamawa State, on the 24th February 2023 to collect the sensitive and non-sensitive materials for the 25th February presidential election and National Assembly elections, and that after collecting the materials, he proceeded together with security agents and other INEC officials, which consisted of presiding officers, assistant presiding officers 1, assistant presiding officer 2, and assistant presiding officer 3 to Madagali Ward that evening to the registration area. This evidence was also to the effect that on the day of the elections, everything went well, and after sorting and counting the votes, the presiding officer did the entry and snapped the results with beavers for the upload and transmission of the results to the INEC portal, but were unable to upload. And when they complained to him, he requested them to come to the registration area. It is therefore clear from the above that the petitioners were unable to establish the allegation of non-compliance by INEC with Section 73(2) of the Electoral Act 2023. The evidence PW2 and exhibits PCQ1 to PCQ6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence, PAPC and Sheriff and others. From the totality of the evidence adduced on this issue, I am of the considered view that petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. 2 is therefore resolved against the petitioners and in favor of the respondent. Issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practices. Here again, we have considered the submissions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting and wrong computation of results. These allegations are contained in paragraph 60, 78 for the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent's scores, which occurred in 18,088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the IRF, and thereby suppressed the lawful scores obtained by the petitioners in the said polling units. He further alleged that in Rivers State, during the collation exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' lawful votes are 205,110, while that of the second and third respondents ought to be 84,108. They similarly allege that in Benue State, the first respondent suppressed the lawful votes obtained by the petitioners when it announced their votes as 308,372, and that of the second and fourth respondents as 310,408, when the actual votes of the petitioners were 329,000, and that of the second and third respondents at 300,421. The petitioners also alleged that the first respondent was purporting to upload the result of the presidential election on the IRF, embarked on massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, as well as uploading incorrect results. He stated that if the results of polling units, votes, local government states are properly tabulated and calculated as required by the Electoral Act and the regulation and guidelines for the election, the overall results of the election and the percentages scored by the political parties will show that the petitioners won the presidential election of 25th February 2023. He stated that the petitioners should rely on a report of inspection of the electoral materials. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the averments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of the material particulars. We held that the said averments contain no particulars of the polling units where the alleged infractions took place or the figures alleged to have been inflated or reduced. We had struck out those paragraphs for offending paragraph 4, 1D and 2 of the first schedule to the Electoral Act 2022. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigations, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. See Omo Borio and others versus Ajasin, Yeso Limited and Honey Legion, Lorin and others versus Tangolana, others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of results of an election. This Sabija versus Tukur. The Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the Evidence Act and cases of Buhari and Obasanjo, Emmanuel Umana, Ipiazu, Oti, Abubakar, and others versus Yaradua, Omishore, Aribashola, Magaji, and All Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mobodo and Ono, Adewale and Olaifa. Also Chima Anoze versus Dr. Ken Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raju Fashola. The Okechuku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, call only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 45B of the first schedule to the Electoral Act. However, even if the statements of those witnesses of the petition were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent and feature proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the election beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and ANEC regulations, he is aware that the presiding officer in the polling unit is mandated to electronically transmit or transfer the result of the election direct to the polling to the collation system as prescribed by ANEC, and to also use the beavers to upload a scanned copy of the polling unit result sheet to the ANEC result viewing portal RF prescribed by ANEC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANEC servers, including virtual servers hosted on AWS Cloud. On cross-examination with his respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANEC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it, like from EC8S. He said he did not have the documents and forms he used, and that everything was in his laptop. Contrary to the speculation of the petitioners that ANEC was not prepared to conduct the promised credible, authentic, and transparent election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANEC chairman, Mahmoud Yakubu, and ANEC National Commissioner, Festus Okoye, wherein they gave assurances that results of the election will be transmitted to the RF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegation of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PCD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent's objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on forms EC8S of 39,556 polling units were inaccessible, as they contain uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,533,553 553,553 and numbers of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs of Forms EC8As matched the results of the first respondent. He stated that the annex CTCs of Forms EC8As showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the ANEC announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling units results, which the witness claimed to have downloaded from the RF portal, showed that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90E of the Evidence Act 2011, case of Emeka versus Ipiazu, others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel Basumana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on RF portal are not the same thing, and that Form EC8A is a paper, while the result on RF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the RF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death nail to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause with 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the RF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the RF portal is not capable of collecting and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is taken to the collection center, which he stated is collected at what local government, state, and national collection centers. He also admitted that since the result in the Form EC8A is taken to the collection centers, the failure to transmit its image in RF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, it would have been different. He further admitted that his report, exhibits PCD1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. On the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition, a report in Exhibit PCJ 3A to F, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commissioned work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of his petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed when as accreditation and voting took place, the votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the RF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the ANEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and ANEC regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day he collected the materials with security agents and other ANEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue by 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the RF portal after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center tech, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well and the results were entered in Form EC8S in the units and were properly announced. He added that the physical copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was subpoenaed, produced, and tendered the following documents. A. Correspondence of documents, letters, emails sent by him, or from Independent National Electoral Commission to National Information Technology Development Agency requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by ANEC for the conduct of 2023 general election. B. The certificate of clearance approval issued by NIDA to ANEC pursuant to any request in A above. C. The report submitted by ANEC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election. It stated that they don't have any of the documents in their office. Under cross-examination by the second and third respondents, he stated that the NIDA Act does not contain cyber security standards. He also stated under cross-examination by the fourth respondent that their supervising ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness is of no assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. The second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay. He settled that hearsay evidence is inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, a certified true copy of the judgment of Federal Court Abuja, suit number FHC ABGCS 1454-2022, was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court, which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collate results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents' counsel to state the score of the of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 said he was not aware that ANEC chairman had given a statement that ANEC will not transmit results electronically. When confronted by the fourth respondent's counsel, he confirmed that his statement on oath wherein he stated that he will rely on the evidence of forensic expert was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. Clear that PW12 relied on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field, Ward 04, Ikun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form PC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by first respondent's counsel, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the ward collation center, which he did. On cross-examination by second and third respondent counsel, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, a petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the legality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast and the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial results of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. The petitioner has a difficult, though not impossible task, close of court. See Mohammed and another versus Anladi and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results where no election took place, and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses they called, only 2 are presiding officers who were present at the polling, who were present at their polling units. Hence, the petitioners have not been able to establish any of those malpractices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent to any of the malpractices which they allege are devoid of any value. The petition allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Learned Counsel for the first respondent contended that to prove overvoting, the direct record of accredited voters and the beavers machines are required alongside the voters register of the affected polling units. He pointed out that the petitioners failed to produce the beavers machines and the voters register. He submitted that the petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degema, LGA, River State, which was part of his report on overvoting. In Exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oetola and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraphs 72, 76, and 77 of the petition, which have been produced here. In the other ruling of this court, the respondents' various perennial objections to the competence of the above petitioner's allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference were not filed along with the petition as to be part of the pleadings. Proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,407 polling units, which affected 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead of 1,807,206 over the first runner-up. He also stated that from his analysis of River State results, the first respondent announced results which were inconsistent with those uploaded on the RF portal. PW4 also stated that from the Forms EC8As downloaded from the RF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. He stated that from the results on the RF portal, LP got 208,564 votes, while EPC got 118,999 votes in River State, as against 175,071 votes for LP and 231,591 votes for APC. He concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections to witnesses and documents made in the earlier part of this judgment, the witnesses stated on oath, the witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to electoral 2022, them not having been filed along with the petition. With the statement of PW4 struck out for being incompetent, exhibits PCD 1, 2, and 3, the forensic report tendered by him, were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in exhibit PCD 1, 2, and 3 are the only evidence adduced by the petitioners to establish the allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, and the forensic report in exhibits PCD 2, 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove their allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the Based on all the foregoing, it is evident that the petitioners have failed to establish their allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and favor of the respondents. But issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. This issue deals with section 134, subsection 2 of the Constitution, and the issue of 25% votes, Abuja. Whatever it is. Well, in resolution of this issue, basically borders on the interpretation of section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue, therefore, is to reproduce, for ease of reference, section 134(2)A and B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the interpretation of which is in contention. It reads thus. A candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation and the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of section 134 quoted above. In particular, the contention is whether or not by the wordings in that paragraph, a candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or his status is to be regarded as distinct from the other states of the Federation, such that scoring 1/4 of votes in the FCT is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principles. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the electoral law reports, where the Supreme Court succinctly reviewed cited cases on interpretation of the Constitution and outlined these principles, guiding principles as follows. A, in interpreting the Constitution, which is the supreme law of the land, mere technical rules of interpretation of statutes will be avoided so as not to defeat the principles of government enshrined therein. Hence, a broader interpretation should be preferred unless there is something in the text or in the rest of the Constitution to indicate that a narrower interpretation will best carry out the objects and purpose of the Constitution. B, all sections of the Constitution are to be construed together and not in isolation. C, where the words are clear and unambiguous, a literal interpretation will be applied, thus according to words, their plain and grammatical meaning. D, where there is ambiguity in any section, a holistic interpretation would be resorted to in order to arrive at the intention of its framers. E, since the draft person is not known to be extravagant with words or provision, every section should be construed in such a manner as not to render other sections redundant or superfluous. F, if the words are ambiguous, the lawmaker's intention must be sought first in the Constitution itself, then in the other legislation and contemporary circumstances by resort to the mischief rule. G, the proper approach to the construction of the Constitution should be one of liberalism, and it is improper to construe any of the provisions of the Constitution as to defeat the obvious ends which the Constitution was envisaged to achieve. In the case of Nafiu Rabiu and the state, Bendel State was Attorney General Federation, Buhari, Obasanjo, Savannah Bang, Ajilo, Abia State was AG Federation. In finding appropriate answer to this issue, I wish to observe first that, with all due respect to counsel to the petitioners, their interpretation of Section 134, subsection 2B of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases, it has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation. And the Federal Capital Territory Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because Toby JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal. So much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provision. The Global Excellence Communication Limited, Donald Duke, AG Bendel State, AG Federation, Saraki versus FRN, Sky Bank PLC, Yugu, Kelim versus Gwabang. That this is the position is not at all open to doubt. In Bronic Motors Limited versus Wema Bank Limited, Nnamani JC or Blessed Memory, speaking from the upper court, confirmed it when, after a painstaking analysis of the cases on the point, said at pages 30 to 32 that, quote, a constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of its provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, the constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of parliament. Although the manner of interpretation of constitutional instrument should give effect to the language used, recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of interpretation of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation or private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which such provisions were intended to serve. Sir Udo Udoma, JSC, very aptly stated this in Nafi Rabiu and the State, where the learned justice said, my lords, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, ut res magis valeat quam tireat. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, will serve to enforce and protect such a clause of court. Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Onogian JSC, later CJN, reiterated the relevant principle of the implementation of the Constitution, which his lordship saying, among others, at page 19. Followed. The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness. Close of court. All these were further followed by this court recently in Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi in the following ways at page 33 of the report. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. See Global Excellence Communication and other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it's meant to guide. The Adeleke or your State House of Assembly. In interpreting the Constitution of a nation, it is the duty of the court to ensure the words of the Constitution preserve the intent of the Constitution. Every Constitution has a life and moving spirit within it, and it is this spirit that forms the raison d'etre of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation, and that while the preamble embodies the hopes and aspirations of the people, the direct principles set out the proximate grounds in the governance of the country. Thakur and Union of India. In other words, in interpreting the words of Section 212(1)A of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision, and where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carries out its objects, purpose must always be preferred. Close of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. Do hereby make and give to ourselves the following Constitution. For those who are not used to reading preambles, the Constitution, still in its fundamental objectives and directive principles of state policy, contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction in Federal Republic of Nigeria and Dingedi, repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their votes. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, to the extent of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider for whatever it is worth their interpretation of Section 134, subsection 2B of the same 1999 Constitution, which incidentally centers around the word "and," that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provisions. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned for another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134(2)(b) of the Constitution will leave no one in doubt that the use of the word "and" by the framework between the words all states in the Federation and the Federal Capital Territory Abuja indicates nothing more than that the framers' understandable desire for consistency in referring to the Federal Capital Territory by that name, as it is done all through the Constitution whenever reference is made to the Federal Capital Territory. The word and Federal Capital Territory Abuja do not by any means imply the meaning imputed to it by the petitioners. In any event, Section 299 of the Constitution dispels any lingering doubt that may still be existing in anyone's mind by stating that the provisions of this Constitution shall apply to the Federal Capital Territory Abuja as if it were one of the states of the Federation, then ABC. This provision states most unequivocally that the entire provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It is noteworthy that the punctuation mark employed by the framers immediately after the part of that provision ending with federation, emphasized by me, is a semicolon, whose function is in a sentence is to separate independent clauses of a compound sentence. The Merriam-Webster's online dictionary, which defines semicolon as a punctuation mark used chiefly in a coordinating function between major sentence elements, such as independent clauses of a compound sentence. Wikipedia also explains its use thus. In the English language, a semicolon is most commonly used to link two independent clauses that are closely related in thought, such as when restating the preceding idea with a different expression. The point being made here is that, contrary to the position of the petitioners, by the express provisions of Section 299 above, the provisions of the entire Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. This means that Section 134, Subsection 2B of the same Constitution, requiring a president candidate to poll at least 1/4 of the votes cast in 2/3 of the states of the Federation in order to be returned elected, means nothing more than that the Federal Capital Territory shall be taken into account in calculating the state 2/3 of states of the Federation. In other words, the FCT is no more than one of the states of the Federation for the purpose of that calculation. Nothing more than that can be implied or inferable from Section 134, Subsection 2B of the Constitution. If anything, this position is confirmed in the cases of Bakari and Ogundipe, where it was said by the Apex Court that by virtue of the provision of Section 299 of the Constitution, it is clear that the Federal Capital of Nigeria has the same status of a state. It is as if it is one of the states of the Federation. And in Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory Abuja is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory Abuja is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory Abuja a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, Subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory Abuja is to be treated as one of states in the calculation of 2/3 of the states of Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory Abuja as the second respondent. In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, issue 4 is also resolved against the petitioners and in favor of the respondents. It is right law that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption with credible evidence. This settled principle was stated by the Supreme Court in Buhari and Anik, and Mesom and Peter Side, others. Also in Udom Gabriel Emmanuel versus Umana Okon Umana and others. Both citations supplied. I have also referred to Abubakar and Eradua, Louis versus Anik, Kiriko, Duluma Hope versus Barrister Joseph Ela and others. From the foregoing, it is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the 3 grounds contained in paragraph 20 of this petition. They have not been able to lead any cogent, credible, and acceptable evidence to rebut the legal presumption of correctness of the result of presidential election held on 25th February 2023, declared by the first respondent. Having resolved all issues, 4 issues in this petition against the petitioners, this petition is clearly unmeritorious. As I stated earlier, it's a consolidated petition. So when we examine that of petition number 4, our learned brothers state their own position. And number 5, sorry.
My Lord, sir, I'm very sorry again, sir.
Yes.
Even if your lordships are going to say, your brethren are going to say their piece later on, sir, at least your own, my Lord, well, you all should be arrested by saying it is either dismissed or is allowed. Huh? I was wondering if your lordship would not pronounce that it's been dismissed. So that...
what are you saying?
I'm sorry, but I don't want to be confused, sir. I've listened to your lordship's eloquent judgment.
Sorry, please, Leonard Senior. You don't have to interrupt judgment. We are delivering judgment and we are still on. Please leave the judgment where it is.
My Lord, I'm very sorry, sir.
If you are confused, when you get the judgment, you read it.
No, my Lord, I'm not confused at all.
Okay, then please.
I'm making a suggestion.
You don't have to suggest to us how to deliver judgment.
I'm sorry.
So you seriously think that all 5 of us wouldn't know that?
My Lord,
wouldn't know what we want
my Lord,
to do?
I apologize.
Better we proceed. Well, we now proceed on petition number 5. The motions in that petition will be read by my learned brother, by my extreme rights.
This is an election petition by the 2 petitioners.
The motions
Here's
in
the
that,
first, second, and third respondents. The first petitioner, Abubakar Atiku, was a candidate at the presidential election held in Nigeria on the 25th day of February 2023. He was sponsored by the second petitioner, People's Democratic Party. The first respondent, INEC, was established as one of the executive bodies created in Section 135 of the Constitution of the Federal Republic of Nigeria, 1999, with power to, among others, organize, undertake, and supervise all elections to the offices of the President and Vice President and others. On Saturday, the 25th of February 2023, the first respondent conducted election to the office of the President and the Vice President of the Federal Republic of Nigeria and the National Assembly simultaneously. The petitioners and the second, third respondents, along with 16 others, participated in the election. At the conclusion of the election, the first respondent declared the results, by which it is indicated as follows. We show the result for out of the 2 contestants here we are concerned with. The APC of Tinubu Bola Ahmed and Tinubu Bola Ahmed scored were declared to have polled 8,794,726 votes, and Atiku and the PDP 6,984,520 votes. Petitioners were aggrieved by the outcome of the election, so they filed jointly this petition to challenge this election. The grounds of the petition were four, and these were stated as follows. One, that the election of second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. The election of the second respondent is invalid by reason of corrupt practices. The second respondent was not duly elected by a majority of lawful votes. The second respondent was at the time of the election not qualified to contest the election. The petitioners are seeking the following relief: that it may be determined that second respondent was not duly elected by the majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent as the winner of the presidential election of the 25th of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. B, that it may be determined that the return of second respondent was by the first respondent was wrongful, unlawful, undue, null and void, having not satisfied the requirements of the Electoral Act and the Constitution of the Federal Republic of Nigeria, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of the states in the Federation, and they put the "and" in capital letters, and the Federal Capital Territory, Abuja. C, that it may be determined that the second respondent was at the time of the election not qualified to contest the said election. E, that it may be determined that the first petitioner having scored the majority of lawful votes cast at the presidential election of Saturday, 25th February, be returned as the winner of the said election and be sworn in as duly elected president of the Federal Republic of Nigeria. In the alternative, another directing the first respondent to conduct a second election runoff, in brackets, between the first petitioner and second respondent. In the further alternative, that the election to the office of the President of Nigeria held on 25th February be nullified and a fresh election rerun be ordered. G, any such further others as the Honorable Court may deem fit to make in the interest of justice. Upon being served with the petition, the respondents joined issues with it by filing the respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. We now proceed to consider them. 7 applications were filed and argued by the respondents during the pre-hearing session of this petition. 2 each of the said applications were filed by the first and second respondents, while 3 were filed by second respondent. First respondents' 2 applications were filed on the 19th of April this year and the 9th of May. The first of his 2 applications dated and filed on the 19th, which also largely reflect the position of second respondent in his first 2 applications and third respondent in his first application. First respondent sought an order striking out paragraphs 92. We gave the paragraphs of the petition on the grounds of their vagueness. Several paragraphs which you get there as you get your the judgment, for being generic, imprecise, and lacking in specificity to elicit a reply from it. B, an order striking out paragraphs 129 and 138 of the petition for failure to join necessary parties. Among other grounds, the 2 necessary parties are Yaya Bello and one Adevo, the chairman of a local government in Kogi State. 3, another striking out the ground of the petition that second respondent did not score majority of lawful votes as contained in paragraph 16C of the petition for incompetence and lacking in specificity and materials in the pleading for a sustenance. Consequent upon 1 to 3 above, another striking out paragraphs A and B and D are sought in paragraph 150 of the petition, and another striking out the ground of the petition that the election is invalid by reason of non-compliance. Consequent upon 5 above, another striking out the ground of the petition alleging that the election of the second respondent is invalid by reason of corrupt practices as contained in paragraph 16B of the petition for lacking specificity and material files in the pleading for a sustenance. 7, another striking out the ground of the petition that the second respondent was at the time of the petition not qualified to contest the election as contained in paragraph 16A of the petition for lacking specificity. 8, another striking out the ground of the petition that the second respondent was at the time of the election not qualified to contest the election. 9, consequent upon 1 to 8 above, another striking out and dismissing the petition for being incompetent, frivolous, vexatious, abusive. In the alternative to the above, another striking out paragraphs prayers A, B, C, and D of the petition are sought in paragraph 150 for being incongruous, contradictory, and self-defeatist. The grounds of the petition were stated there, and we set them out, which you get. Second respondent also filed a similar preliminary objection application for preliminary objection, seeking striking out the petition or portions of it. A single prayer on the application is an order of the court striking out jointly and or severally paragraphs 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on this part in his first application on the same issue filed, we gave the date, sought similar prayers like first and second respondents. All three respondents also had issues with the replies petitioners served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so have no place in the reply. For these same reasons, they sought striking out with additional witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following four grounds: that the entire petition constituted a gross abuse of the process of court by reason of an originating summons in suit number SCCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by the second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation, where the said plaintiffs raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit polling unit results from his BVAS to his result viewing portal IREV in the 25th February 2023 general elections. The plaintiffs wherein first respondent mentioned sought in their suit declarations that the 2023 elections were fundamentally flawed and so invalid, null and of no effect, which is what petitioners also seek here. So this petition constitutes gross abuse of process. There were other grounds for that application, as I shall show later when considering it. All 7 applications were supported with affidavits and written submissions of applicants, which were in turn countered by the petitioners with counter affidavits and written submissions of their own. I shall now proceed to consider the merits of the applications. For ease of reference, I shall group the 3 sets of applications into groups A, B, and C. I start with the first 3 applications of respondents that attacked the validity of the petition and all its paragraph reliefs claimed and grounds on which it was sought. First respondent's first application, that is the one filed on 9th of April. I start with that one. First respondent set out the following issues for determination in his 9th April 2023 application. Set them out. It argues its issues 1 and 3, you get it, so there's no point arguing it, time is going. It argues its issues 1 and 2 above separately and took issues 3 and 4 together. In seeking the striking out of paragraphs 9, 2, 3, 93, all set out there, of the petition on grounds of their vagueness, imprecision, and lack of specificity to elicit a reply from it, first respondent, that is INEC, relied principally on paragraph 4.1, sub 1 of the first schedule to the electoral act, which states as follows. It says, an election petition under the act shall state clearly the facts of the election petition and the grounds on which the petition is based, and the relief sought by the petitioners. Relying on Ugu and Ararume and the number of cases all set out there, counsel on first respondents have argued that paragraph 4.1, the said paragraph 4.1 of the first schedule of the electoral act implies compulsion and makes it mandatory for petitioners to plead the facts of their petition. They submitted that an election petition that is vague, imprecise, omnibus, nebulous, or generic is contrary to the provisions of paragraph 4.1d of the Electoral Act and so liable to be struck out. Let counsel then carefully took on each of the said paragraphs and advanced reasons why they are vague, generic as a complaint. Counsel also argued that the petitioners in paragraphs 129 and 130 of their petition made allegations of unlawful acts allegedly carried out by one Honorable Friday Adejo, Governor Yaya Bello of Kogi State, and some unnamed persons in the course of the presidential election. Yet those persons were not joined to the petition, so those 2 paragraphs are also liable to be struck out. Counsel cited Bambe and Adetunji, Olori Ode vs. Oyebi, and Babatola and Alade Jono to say the court lacked jurisdiction to enter judgment or make orders against persons that are not before it. Responding to the first limb of first respondents' contention, that the said paragraphs of the petition are vague and imprecise, the senior counsel to the petitioners argued that the said paragraphs were pleaded in support of the second ground of the petition, alleging that the presidential election was bedeviled by corrupt practices. Prime among those practices, they said, are suppression of votes, manipulation of beavers' machines, and destruction of electoral materials and ballot boxes. Specific instances of these corrupt practices that took place in various states and local governments, they argued, were laid bare in the petition with particulars of the allegation. They argued that first respondent, instead of considering the paragraphs of the petition holistically, seems to have considered them in isolation and apparently hence its wrong conclusion that the petition was vague, imprecise, and without necessary further particulars. While admitting that the names of polling units were not specifically stated in the petition, Petitioners' counsel submitted that petitioners stated in different paragraphs of the petition that the polling unit results, polling units affected were to be contained in the statistician's report to be relied upon at the hearing of the petition. They cited the cases of Oluwedun vs. Ajayi, Awolaja and others, as Citrate and East Horizon Gas Limited versus EFIOC and others. To submit that petitioners have by that pleading incorporated by reference the said statistician's reports. On the argument of the first respondent that the petition did not disclose any reasonable cause of action and so constituted abuse of process, petitioners' counsel argued that first respondent was by that argument trivializing matters of high constitutional importance raised by petitioners in the petition. Submitted that a petition that touches on correct interpretation of section 133(2)b of the Constitution of this country, vis-a-vis the return of second respondent and the qualification or disqualification of second respondent, regulated solely by sections 131 and 137 of the Constitution, cannot by any means said to disclose no reasonable cause of action. On first respondent's contention that petitioners' failure to join Honorable Adejo and Governor Yahaya Bello and unnamed thugs against whom they made allegations of criminal misconduct in paragraphs 129 and 133 of their petition made those paragraphs of the petition incompetent and liable to be struck out. Counsel to the petitioner submitted that section 132 of the Electoral Act has specified the persons who may be joined as petitioners or respondents in an election petition. That Honorable Friday Adejo and Governor Yahaya Bello, having not participated in the election or returned, petitioners are not in violation of the Electoral Act or any rule of law in not joining them. Besides, they also argued, no relief was claimed against the said two men, so they cannot be said to be affected in any way by the eventual outcome of the petition. Now, this is the way we resolve this. My Lord, resolved it. Now, paragraph 4.1 of the first schedule of the Electoral Act, as amended, states thus. 2020 states thus. An election petition under this act shall D. State clearly the facts of the petition, and the ground or grounds on which the petition is based and relief sought by the petition. This provision is so clear and direct that it does not require any aid in its interpretation. It simply restates in mandatory terms the first rule of pleading that claimants, in this case a petitioner, shall state clearly, quote and unquote, the facts of the election petition, end quote again, and the ground or grounds on which the petition or claim is brought. This requirement / duty to plead one's complaints and facts clearly in the statement of claim / petition, not reply, is a basic rule of pleading even in ordinary civil proceedings. Emeka Agu in JSC, Natonda versus Ajani, put that point across most forcefully when he said that, and I quote, he said, it appears to me that rule which required every fact, upon which a party intends to rely at the hearing of the goes to the fundamentals of justice. For no one can defend the unknown. If one has to defend or counter a fact made by his adversary, the one must have due notice of that fact to enable him prepare for his defense. That is the very essence of pleading. As it goes to the very root of the rule of audi alteram partem, one of the twin pillars of justice, it would be misconception to describe it as mere technicality or irregularity. It's a matter which cannot be waived. Indeed, by a long line of decided cases, it has been long settled that any evidence on the fact that ought to have been pleaded but is not, goes to no issue at all at the trial and ought to be disregarded, end quote. Now, the complaint of first respondent is that the petitioners in their petition did not state their case as clearly as required by section 4.1d of the Electoral Act, 2002. It complains that petitioners' complaints were vague, imprecise, and lacking in particulars. It does not appear to me that this complaint can by any means be waved away as idle. If anything, even the petitioners seem to have admitted that they did not plead those necessary facts. But their response to that contention, as shown earlier, is that they pleaded a statistician's report, which contains the required details of the polling units where the corrupt practices they alleged took place. Incidentally, the said report, a very voluminous four-part document, the later tendered through his maker, Mr. Samuel Oduton, PW1, during the trial, shows on his face that it did not even exist at the time they filed their petition, and so was not served on respondents along with the petition to enable them exercise their constitutionally guaranteed right of responding fairly to the corrupt practices, quote and unquote, alleged particularized in it, and if necessary, also engage their own expert to reply to it. Engage their own expert to reply to it. Yes, the principle of incorporation, by reference relied on by them, that is petitioners, is part of our adjectival law and is supported by a fairly long line of cases, including MMA versus NMA, Ekpemupolo versus Edremoda and others, JFS Investment versus Brawalai Limited, Elo versus Idaosa, Abode Brothers Limited versus Niger Construction Company Limited, and another. But that principle cannot by any means override the fair hearing trial provisions of Section 36 of the 1999 Constitution of this Constitution, which also underpins the rationale for exchange of pleadings by parties. See once again the dictum of Naimeka and Atonda and Ajani already quoted. A statistician's report that is supposed to contain missing particulars in a petition, but which was only filed in the middle of hearing of the same petition, long after the time for exchange of pleadings had closed and even after petitioners had called as many as 16 witnesses in proof of their case, as happened in this case, cannot serve that purpose of audi alteram partem, let the other party also be heard too. In short, the tactics employed by the petitioners in this case as regards their pleadings, and the petitioners and the statistician's report referred in it, is to say the least most unfair and definitely negates the current practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statistician's report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent, but it shall only be as they stand in the petition. In that regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State, is lacking in particulars of the particular polling units affected and so liable to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think sufficiently meets the requirements of paragraph 41D of the first schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units in some local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is in my opinion bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondents allegedly depleted and inflated respectively. The need to plead the exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the first schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims a seat alleging that he had the highest number of valid votes cast at the election, which is what the petitioners are doing here, the party defending the election or return shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed. Second and third respondents can only properly exercise their right under this provision, requiring them to, quote, give particulars of the votes claimed by the petitioners that they object to and the reasons for the objection against such votes, after petitioners have themselves set out clearly the lawful votes depleted by the manipulation alleged by them. Paragraph 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as the petitioners have stated in those two paragraphs that the disruption of elections in Adavi and OKE local government areas of Kogi State by agents of second and third respondents, alleged hearing was captured in video recording which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. It is therefore also liable to be struck out. I am also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof which is a matter for the substantive hearing, especially as infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election material, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and what these failures enabled the results of the polling units in the said LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as to the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly says so, my lord. We have already produced all these things in appropriate response from respondents, even more so as paragraph 104 merely alleged bypass by first responder of use of beavers machines. The presidential election in Benue State, while paragraphs 105 and 106 simply stated the petition as ground that second respondent was not elected by majority of lawful votes. In respect of paragraph 104 of the petition, first respondent complains that the petitioners there contended that the entire results of the presidential election were wrong, yet they did not plead the results they perceived to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1 C of the first schedule of the Electoral Act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of section 134B of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they have that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondent, so I shall overlook it, at least for now. The petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units failed to properly fill and countersign alterations in election forms, including forms E of the 1999 Constitution of the Federal Republic of Nigeria, did not mention the polling units. What local government and state said infractions? I am afraid paragraph 114 of the petition 115 and 116 and paragraph 4, where they said purported results from 6. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report, pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondents, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent Against paragraph 129 of the petition, that is also deserves to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled. It's well made. The petitioner's response that not only was not explained by them against Honorable Adejo,
because given the quantum of evidence and what is required, the number of units
to be joined to an election petition is not a valid response. Section 133, elections in the Electoral Act only deals with the issue of which contestants of an election. Petitioner's response that not only was not a co-contestant, Honorable Adejo, has nothing to do not even participating in third parties against allegations and what is required and made by the number of units to be joined to an election petition must be joined to the petition if the court is not. Section 133, the risk of infringing their fundamental rights fair hearing guaranteed which contestants of an election. Petitioner's response that not only was not a co-contestant, Honorable Adejo, but that notification of joining by third party to make findings the number of units joined to an election petitions must be joined to the petition where necessary. Section 133, the risk of infringing their fundamental rights fair hearing can be found in one election. It's also where that was a co-contestant, Honorable Adejo, but that notification 1441 sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022. And confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what His Lordship said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is in issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, His Lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out. And the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eitai Ojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State leading talks to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also barred for non-joinder. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria People's Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also barred and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of president, the whole of the federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the federation or even the federal capital territory only become of consequence when the issue verges on whether the candidate returned also satisfied the provisions of Section 131B and 2 of the 1999 Constitution, as amended, requiring him to poll 25% of votes cast in at least two-thirds of the 36 states and the federal capital territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By Section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition, the person returned as the winner of the election. See further on this, the cases of Buhari and another versus Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others. See particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, an unsuccessful candidate in an election cannot be made a party to an election petition against his will, end quote. We also do not agree with first respondent that paragraphs 141, 141, and 142 of the petition were vague or imprecise. But I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results. For 22 name states herein, paragraph 44, where they aver that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where these said quote and unquote large scale discrepancies took place. And paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground 4 of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said, is also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41b of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused in the petition of committing electoral malpractices, paragraphs 92, 95, 98, 11, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 41b. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140. On the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether, having regard to the mandatory provisions of paragraph 41b of the first schedule of the Electoral Act, a reasonable cause of action has been disclosed in respect of grounds of the petition contained in paragraph 16a, b, C, and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraph 16a, b, and C of the petition where the petitioners alleged, we set them out. The next reference, section 134 of the Electoral Act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1). So the fact that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the Act, if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and the non-compliance would have substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, Senate Council submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. That not only did the petitioners not assert in their petition that the non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court to form an opinion on that non-compliance and corrupt practices complained of substantially affected the result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioners' counsel submitted have simply blown quote-unquote muted trumpets and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners are aware that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election, in that the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. Answer to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition as by reason of the alleged submission in the petition identified above had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction. Entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issues 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. For this application, letter counsel second respondent simply said that the sole issue for determination thus was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant Electoral Act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, and 108 of the petition are not liable to be struck out. We set out the arguments, both of them. He said, in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. Same exercise are also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitioners, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we listened, and we said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 147 of the petition omitted by the first respondent in the application determined the complaints of second respondent of whether petitioners' complaints in those paragraphs were vague, imprecise, and generic. I now start that exercise without reference to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the averments in the petition. I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the we did not also find paragraphs 20 to 20 of the petition where the petitioners complained that first respondent did not keep to its earlier promise of electronic transmission of election results to its IRF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)(d) and 15 of the first schedule of the Electoral Act 2022, the averments in paragraph 23 of the petition, where the petitioners complain that the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 27 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters' cards collected in unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first respondent, first petitioner, and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters' cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in the conduct of the election, which practices they complained took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondent's votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akpo and Port Harcourt local government areas of Rivers State did not reflect the actual votes. If not express the actual votes scored in the said local government areas, or even those updated to IRF by INEC and so liable to be voided, no correct quote unquote figures of the actual votes cast as reflected in the IRF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of amendments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 41D of the first schedule of the Electoral Act. In pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by learned counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty on second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka JSC while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of the trial tribunal in that case that paragraph 12 sub 5 of the first schedule to the Electoral Act, same as paragraph 12.5 of this present Electoral Act, permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by Section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defy it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again one Yaradua citation given. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. In his own application of 8th May, third respondent, like the first and second respondents, also prayed us to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogi State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argue in response that their complaints were properly pleaded in the petition, so not imprecise, nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents relates to the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. We further hold that petitioners' amendments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas the issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house expert from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners, sorry, what is here? In petitioners, the amendments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses, testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraph 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out as prayed. The remaining paragraphs of the petition attacks past the vagueness test and paragraph 41D of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent also filed on 8th of May 2023, as well as the three applications of third respondents, all objecting to the petitioner's replies to their petition, to their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, then we went on to say that the thrust of the response of petitioner's counsel, that is 45543. Thrust of the petitioner's counsel is a suit number SCV 351 that was not filed by the petitioners. So this petition, sorry, okay, I'm still reading 544. That now it is settled position of the law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See your CAF of Attorney General of Anambra State. It necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Alhaji EstiQ Abubakar, and his political party, the PDP, can be properly described as previous of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response. But the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is recent new currency case. The new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case, the said suit number SCCV 354, 2023, filed by the plaintiff in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. Just simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. The proper sanction in circumstances of this case, as we have already pointed out, citing Nwankwo and Yaradua, to strike out the paragraphs of the petition where those allegations were made. That order we also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutige and Pastor Chalon on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. Okay. So the next one, we now go to the challenges, the replies filed with the petitioners. All three respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner, and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They sought striking out of paragraphs 1.121, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the petition as Senator Dino Melaye, and PDPC, both deposed on 20th April, striking out the petitioner's list of additional documents dated 20th day of April, which accompanied it. Sorry. Thrust of the argument, which is counsel founded principally, and we reproduced the argument, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. The second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be had to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in temple of justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. That obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of petitioners, therefore rejected. Coming now to the merits of the application, it is common ground that the provisions of the electoral act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. Cited cases, I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this sin only restates the well-settled position of adjective law that a claimant's claim or grievances are made in the statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Olubodu and Lawal. He cited what the Supreme Court said there. He said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad, and no evidence would be admissible in his proof, end quote. In fact, that settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied. This is cited. As to what will amount to a new issue, we cite again Egesimba versus Nuzurike, earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners into their reply. The additional averments of how results could not have been uploaded to INEC's IREV after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it. Not to talk of the repetitions reply of averments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the Schedule of the Electoral Act, particularly as relates to the further details as are quote and unquote as petitioners labeled them in their reply of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. It bears reiterating that all that the petitioners referred to in paragraph 146 of their petition is the bare statement that, quote, the petitioners averred that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by the documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seemed to have had no clear idea of what they meant by second respondent's non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications the person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61(a) of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 2(1)(b) of their reply that they were simply given, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they averred in paragraph 1(b) of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)(b) and C of the reply, where petitioners aver to no uploading of polling unit results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues or at least mere further denials by the petitioners Respondent denials of the petition. Such is not also permitted in reply. See again, Bakar and another. Versus Ibrahim, Akeredolu versus Akinremi, Egesim versus Onuzurike, Spasco versus Alrain, Ishola versus LGB, and both versus CBN. In the light of all the foregoing, the two witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in issue, are also incompetent and liable to be struck out. In summary, first respondent's applications of 9th May succeeds in its entirety. Accordingly, paragraphs 1, 2, stated them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2.1b, 2.1b, C, and D of the petitioner's reply, filed in response to the reply of first respondent together with the two witness statements on oath and list of documents which accompany that reply are all hereby struck out. Second respondent's application seeking striking out the self-respondents. Learned counsel also made his arguments, and then we come straight to the resolution. And I said here, my Lord said here, that I'm not even in the least persuaded by the argument of the petitioners, that they simply reply to new issues raised by second respondents in reply to their petition. The petitioners, like they did in their reply to the reply of first respondent, introduced fresh facts and issues of non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1A to the first schedule of the Electoral Act expressly forbids. Consequently, paragraphs 1B, 1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. Second respondent, wherein petitioners avert new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24b of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, now we come to third respondent's application. And we come straight to say that I find necessary to first observe that, like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist disqualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 16A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, that last paragraph 35, are, as third respondent's counsel rightly pointed out, either mere denials of third respondent's reply to the petition or repetitions of petitioners' averments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act. See again the cited cases. It's also not the law, as erroneously argued by petitioners' counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. Somehow, counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. Here against Simba's case, Ayola GSC, I cited the summary. Third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians who want to call it, so that my Lord can continue from there.
We'll go to the respondents' objections to documents tendered at the trial. My learned brother, by my immediate right, read the ruling.
Thank you. We want to take on the respondents' objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the three respondents. First, to the validity of the witness statements on oath deposed to by some of the witnesses of the petition. Specifically, EW12, that is petitioner's 12th witness, Eguma Friday. PW13, that is Grace Timothy. PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obasa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohamed Haruna. PW21, Mr. Samuel Odunta, a statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulus Ado. PW25, Victoria Sani. PW26, Hitler Egwonu Nwala, a forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties. The ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1, the validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents Council on 8th of June 2023, when PW12, Mr. Eguma Omachonu Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June